Okay, let's start. Welcome to this panel on government access to the cloud, hosted and arranged by the University of Maine. My name is Jeppesen with the Center for Democracy and Technology here in Brussels. Very pleased to participate in the conference, and CDT is very happy to be a supporter of the conference this year. Now, the topic of the panel is one that our organization has worked on extensively, both before the NSA revelations began and after. We and other groups have, for several years, cautioned against privacy-invasive government surveillance in the area of big data analytics and ubiquitous global connectivity. And the revelations have, of course, brought these issues to the fore of the agenda in a dramatic way. And we've been very active in this field, pushing for legislative reform in the US, engaging with the UN, and assisting the European Committee, the European Parliament Libe Committee inquiry, and so on and so forth. This panel will be able to examine this issue from all angles, because we're fortunate to have with us experts with backgrounds from all around, data protection authorities, cloud and technology companies, the intelligence community, academia, and civil society. So we are set for a fascinating discussion, and it'll be led by Omer, who's Vice President of Research and Education at the IAPP. Also, he holds positions with the College of Management School of Law, Rishon LeZion in Israel, and Stanford Center for Internet and Society, as well as the University of Maine, the organizer of the panel. Marit Hansen is Deputy Privacy and Information Commissioner of Land Schleswig-Holstein, Germany, and Deputy Chief of Unabhängiges Landeszentrum für Datenschutz. I hope I'm doing justice to that. In charge of the Privacy by Design Department and the Innovation Center, Privacy and Security. She's worked in many areas of this, anonymity, pseudonymity, identity management, biometrics, and so forth, including in several EU-funded projects. Cornelia Kutterer from Microsoft, Director of Regulatory Policy, focuses in particular on security and data access governance issues, child safety, and consumer policy. She has also previously worked for the European Consumers Association as head of the legal department, driving their digital policy agenda. Bryan Cunningham is a cybersecurity and privacy lawyer, advises clients, companies, government, and multinational entities on information security and privacy programs. He's authored several books and chapters in books on these topics, and has held senior positions in intelligence and law enforcement in the US government, most recently as Deputy Legal Advisor to the then National Security Advisor, Condoleezza Rice. That's the other NSA, I gather. We have with us also Joris van Hoboken, a Microsoft postdoctoral research fellow at the the Information Law Institute at the New York University, and he works in law and policy in the field of digital media, electronic communications, and the internet, with a focus on freedom of expression and privacy. And before joining NYU, he was a researcher at the Institute of Information Law at the University of Amsterdam, and is also a chair of the board of directors of Bits of Freedom, the Dutch NGO. And with that, over to you, Omer.
Thanks a lot, Jens. So I actually wanted to start with a general question. You know, it goes without saying that the Snowden revelations have had a profound impact on trust, security, and privacy in the cloud, which are the topics for this session. So I just wanted to ask each of the panelists to tell us what the most important news, or you know, maybe something we didn't suspect before, is from the Snowden revelations. except for maybe that you shouldn't leave your workstation open and unsecured if you work at NSA. So starting with you, Joris.
So just to be as specific as possible and not take too much time on this question, I think for me, definitely the revelation that struck me most is the extent to which intelligence agencies and then the NSA in particular were corrupting security standards and the technology. And I think more generally that kind of influence over technology development that is then used within society for economic, social, and just general societal purposes, that kind of influence in pushing that into what they call in some documents a SIGINT-friendly direction. I think this is very worrying for civil and political liberties, and that's definitely what struck me most in the revelations.
Cornelia? So the integrity of the infrastructure.
Yeah, I think what we have been looking at cybersecurity and the developments in that field for long, and new threats that have occurred, and I guess the extent of the revelation have made clear that those threats are coming from all sorts of sources, including governments, and I think it's not totally unexpected, but at least it has put the focus here, certainly, and how companies need to help themselves to secure their customer data.
Thank you. Jens, you're not off the hook.
I'm not off the hook. I suppose one area that's really struck a lot of people and has created a huge amount of concern, certainly in the U.S., is the nature of collection that is bulk data. So it's everybody's data. I think a lot of people... Mass surveillance. A lot of people have, and you still hear the argument, have said, well, I have nothing to fear, I have nothing to hide, but they have not realized the extent to which everybody's data was subject to collection.
Bryan?
Well, on one specific point, I want to agree with Joris and echo what he said. I do a lot of work with white hat, black hat, gray hat hackers, and the revelations, if true, that the U.S. intelligence community was influencing encryption and other standards, particularly if that was in a covert way, that is without, it's one thing to have, for NSA to have a meeting with NIST and tell them what they think. It's another thing if they did it covertly, and I don't think that's clear yet, but if that's true, that's really shaking the core of a lot of people who, whatever their political leanings are, you need them to make cybersecurity work, and that is the IT professionals in the U.S. and around the world. More broadly, I think one of the biggest impacts, you know, it's sort of easy to focus on the sensational nature of some of the specific revelations, but the extent to which we now are all aware of not only U.S. intelligence collection, but a lot of European country intelligence collection, and the sweep and the breadth of it, I think a lot of people sort of in the back of their minds suspected that those kind of things were going on, but to have it confirmed, you know, I think a lot of the disclosures were very damaging to U.S. security and European security, but to the extent that they fueled a dialogue with the people of each country about what their intelligence services should do, I think that's a pretty striking and important development.
Thank you. So I'd like to add two more points here. The mass surveillance, okay, you said that already, but the little success rate, the very small success rate, which is really in no relation. And I think this is something very new, and it was, of course, only now in the aftermath of all the revelations. And the other thing, the quite tame reactions of citizens, of government, not, at least so far. Perhaps it will change now, I hope very much for that, but otherwise it has not changed that much. Of course, many people say it's really bad, and we also, as a data protection commissioner, we thought it's now better for us. It's easier to go ahead and have our ideas being implemented, but it's the other way around, that so many people are now so frustrated that they say, as a data protection officer in a company, I cannot do anything anymore, because always if I say you should improve here or do that, they say, but what should we do? NSA knows everything, can store everything. Why should we protect what is stated in the law?
Yeah, it certainly puts into perspective, I think, some of what we do as privacy professionals. Thanks. As privacy professionals, dealing with cookies and with consent and with purpose limitation here and there, and like there's this huge vacuum cleaner that's sweeping everything up. I just wanted to ask, do you think we actually know the real success rate? Because, you know, we hear some numbers thrown around. Bryan, do you think like maybe there are success stories we don't know about?
Well, I think the first thing to say about that is I think I worked for 3 different administrations, and I think it's true in the U.S. and it's true in most countries that we focus way too much on what the law says. Successive administrations in the U.S. seem to have taken the position that if my lawyers say it's okay, I'm going to do it. They don't ask if it's moral, if it's ethical, if it's consistent with our values. And to me, this efficacy question needs to be the very first question. Because if a program like the bulk collection of telephone records is not effective, then I don't care if it's lawful under the Fourth Amendment or under any U.S. law, it shouldn't be done. And I think that we've up until recently paid too little attention to that. I will say, having been a drug cartel prosecutor in the Clinton administration, when the use of toll records was by far the single most effective tool that we had at taking down drug cartels, I'm quite shocked at the revelations. I think the D&I panel said that the database had only been queried something like 5 or 6 or 7 or 8 times in a year. And then to be able to come up with no success stories is troubling, but it's also a little hard to believe. And the fact that you had 2 American judges appointed by 2 different presidents of different political parties come to the exact opposite conclusion about whether or not the program had been effective says to me there's something out there that we just don't know yet.
Joris, what do you think about this? Success, proven success, like classified or unclassified?
So I don't think I'm in a position to really answer that question very specifically. Yeah, so I think there's been like quite an extensive debate about that, and so it's one thing also like there are measurements that courts would have in puts like in terms of the guarantees that are there for the amount of data that can be collected and then there should also be more generally a policy debate, you know, like because maybe what is legal should still not be done, no? And I think especially from the U.S. perspective, there is that question in the international context that what can be done under international law is harming a variety of interests abroad, including also U.S. business itself. And so I think also what has struck me looking at like the kind of capacities that have been developed by the intelligence community is that to some extent it seems that they have been looking just in general to develop this kind of capabilities on a mass scale, no, with like collecting enormous amounts of information and maybe also studying, know what can be done with this kind of data. And I can also imagine that an organization like the NSA, maybe they have not at this point been able to do something effectively with this kind of data, but they want to be the first in the world that develops like the methods on those kind of data sets to be effective. And I think so there's another layer in what is done by intelligence communities with data. It's like they have this idea of maybe in the future this will be the kind of intelligence capacity that we need, and we need to be the first one to develop.
It's like a big research and development.
Yeah, it's kind of, it becomes like surveillance at some point becomes like part of R&D in view of future surveillance. And I think, so then discussion really shifts to a meta level, and I think that that is actually very worrying, that the surveillance can be, the goal can be to develop new surveillance in the
like
future.
human subject research. I want to sort of frame the next questions, and you know, we are interested in privacy generally here, and I want to explore first of all technological solutions and then policy or legal responses. So first, in terms of technological solutions, I think the main sort of 2 buckets we discuss and hear about are encryption standards, which we've already heard may be suspect or being corrupted, and data localization. So, you know, if the U.S. is intrusive, not storing data in the U.S., although of course we don't know that other countries are not intrusive or less intrusive, maybe have less capabilities. Maybe let's start with localization, given that there was a couple of strong statements yesterday by Brad Smith, the general counsel, right, of Microsoft, speaking in Davos about keeping data away from the U.S. Is that helpful at all? Does the NSA not have reach? Maybe it's better to be in the U.S. because at least then you might be considered a U.S. person. Cornelia.
Thanks, Omer. So I think Brad Smith's speeches and his interview with the Financial Times have shown a clear direction of where Microsoft is going. How we reacted to that, and it also is a response to customer choice and wishes where that is necessary. And I want to give you a couple of those directions that he has indicated, actually not only this week, but over the last couple of weeks and months. We have already been engaged with the Global Network Initiative in order to put in place and implement the principles that the Global Network Initiative has developed in the context of law enforcement data access requests by government. With the revelation, we have clearly recognized the need for even more transparency in that space, and are seeking to be allowed to include in those reports the secret FISA court orders if we have received so. We have obviously also there hasn't been any evidence that any of the communication between data centers has been intercepted, as that was the case in the revelations, as we've seen in the Washington Post. But nevertheless, we have taken that as an point to look into our encryption strategy and roadmap, and there is a roadmap underway to look at all the networks and services to increase encryption. We have also increased our efforts in the context of transparency to allow governments to review whether or not to allow them to look themselves that we do not have backdoors in our software. And then I think the one point where I can talk most to in the context of European law, because I'm a European lawyer, I'm not a technical expert, is the way we think about legal protections, and that is something he has also made clear in terms of looking at defenses, that we can use legal defenses where governments ask for data that is stored in other countries' territory.
Bryan, a European cloud is a solution to NSA surveillance.
I think the announcement by Microsoft is an important one and a valuable one for several reasons. One is responding to their customers, and I think it will lead the way to other American companies doing the same. That said, I don't think anybody should take a strong sense of security that movement to clouds in Europe or anywhere else outside the United States is going to provide a lot of protection from American intelligence collection and American law enforcement activity. First of all, as I think everybody realizes now, American intelligence collection outside the United States is far less regulated, far less subject to oversight and scrutiny and judicial control than it is in the United States. Secondly, any company that has a U.S. presence, whether it's a U.S. company or a foreign company, and one American court has said even if you have bank accounts in the United States, is subject to demands by U.S. courts to bring information to them, regardless of where the servers are. And third, of course, the United States is not the only country in the world that's collecting intelligence. And in many European countries, and certainly in countries like Russia and China, with far fewer rules than we have in the United States. And finally, I think the U.S. is a little bit ahead of some other countries in just our overall cybersecurity infrastructure protection. So if you're talking about a threat not from, actual intelligence services, but from hackers and identity thieves and that kind of thing, I'm not sure you're more secure being located outside the United States than inside.
So, Marit, is the European cloud a red herring?
Not necessarily, but I agree with Bryan that right now the access rights, the legal rights for US government, for NSA to access data, even if it's not inside the country, it's there, so it's no legal protection. And from the technology protection, of course, you have to discuss what does it mean. Is a European cloud really something where no access outside can happen? Probably not, because also Europeans travel and want to access their clouds, in their data in the European cloud from outside, so there must not be a blocking of American IP addresses or so. So this is not so easy, and usually the administrators work through the night, but not because of night shifts, but because of follow the sun being in different countries. So probably there are also Indian administrators. Meaning, of course, there's the access possibility. So probably we have to go into other directions. And if you still ask for a technology solution, I think we need to be very transparent on what is happening. And very often the entries log file entries are generated but not checked, or it's not clear how to check. So of course I'd like to see reasons for access to be given, to be bound to the access item itself, and that can and should and must be checked by independent, could be authorities, ombudsman or so, that it's clear that if there's a reason for the access, that it can be challenged, that this can be something where a redress later on is possible or so. Right now, and therefore I'm not sure about the 5 access issues only per year. Has there been a good logging system within the NSA data themselves? Probably not, because they are still not so sure what was really revealed to Edward Snowden. And if they had more access control mechanisms, probably they at least would have known and could have prevented much of that. And now again to the European cloud idea. If we think there has to be also access for specific reasons, it could be local law enforcement, which we are not discussing so much here right now, but it depends, it falls under the item, of course, then that we really can have accountability for that also the provider of the cloud can prove that he did everything all right, and that everything can be challenged. And then the next step is not only transparency, but also how to deal with the data, checking of course, but then be able to intervene if necessary. And even if we find out that the law is crap, that this has to be changed, of course, or that the reasons are given in non descriptive way or so. We have similar things with our local police also. So they have to give some information, but often it's easier to click with some was necessary or so statement, and of course this is not sufficient. Right now I think it's really difficult, and imagine in a technology system where each access already notifies people concerned directly. Of course you don't want that for law enforcement, you often have to have some period before, but this might be something you can suppress again if you argue, if it's a balancing of the schema then, that you have a reason also for not notifying immediately, but otherwise that people are informed. For example, the tax authorities, if they really want to access a bank account, why not asking first the company, and then if they don't get information, access the data and then inform immediately that it's clear that this access has happened. Right now the incentives are, I think, in the other way, not informing, and also of course putting pressure on the providers, even if they would like to stop that. I think probably it's not possible for them. And then I like to, at least if we come to legal issues, it could support some contractual measures. That first there's the contract, that the notification has to take place for the individual or the organization, the cloud client, the consumer, or what is the cloud user. And if not, then of course it can be quite expensive because it's a violation of the contract.
Jens?
I just wanted to add one or 2 points. I think I think I agree that the ideas of data localization and routing traffic to avoid certain geographies is probably not those are not measures that would enhance protection of data or defend against spying in an effective way. However, I think that it's quite understandable as a political reaction to the revelations. And I think one benefit, if you will, that these types of ideas will have spurned is that it has shown the U.S. government that there would be economic and business implications of these programs that would be very, very negative for U.S. Companies. So in that sense, as a political message, it has been a way to motivate reform. We would also say that it would have negative consequences in the sense of motivating perhaps other countries and authoritarian regimes to take up these sorts of ideas for much less admirable purposes, namely to control their citizenship and curb free expression and so forth. Thank you.
So, Cornelia, I think you get to respond. Could this be actually a step in the wrong direction?
So clearly, I want to go back to the data localization requirements and just give an example of European discussions currently. In the context of the Commission's cloud strategy, there has been efforts to think about enhanced procedure. It's a tool of the Lisbon Treaty that allows some member states to advance quicker in certain areas of law than the rest of the 28 member states in order to precisely get rid of data localization requirements. And in the reiterations of this thinking, there has been mentioned 3 areas of law. It has been financial services, health, and law enforcement, in each of which there are specific national examples of data localization requirements. Within those countries, they would then allow basically to have the data stored in one of the other 9 member states, which obviously then also requires that the specific enforcement authorities, be it tax or be it in the context of some other legal professions, they might be able to access that data in the other country. So what I want to say with that is that we have areas of law where there is precisely the other way around, where you have thoughts around having data access directly in another country, even for good reasons. So if you look at all the laws that are currently somewhere discussed, I think we need to sort them a little bit out and think about them. I'll give you a couple of examples. There is criminal procedural law, national criminal procedural law in a number of European countries where direct data access, which resides in another country, is in principle possible. We do have a number of EU-US agreements where that is possible, which might be disputed, but at least they are there. And there's also other discussions. We have an ongoing discussion on EU-US umbrella agreement for data protection. There's the Budapest Convention. And I think once we start to look at legal solutions, there are at least, we are not in a total void, at least when it comes to law enforcement issues, and there are sometimes not so separated from what we are talking about here. And I think we need to look at both. European cloud for me doesn't really mean anything. We have, as a company, we have data centers in different regions of the world. We do have data centers in Europe, and that is where we give our enterprise customers the choice to say we want to have it there. And in a way, I think for most customers, there will be a process of thinking about data classifications and the risks that are there in a broader context of cybersecurity. So all of those little pieces of the puzzle we'll need to sort out and then think about where further reform, where legal reform is necessary. And hence, one of the other, which I haven't mentioned at the beginning, one of the other areas that Brad has directed to is that we indeed need some more discussion about international agreements. And as I say, there are some that are in place we can start looking at. And of course, there is a more joint industry approach to push for reform. And that reform push does not end at the United States borders, but that is a broader discussion from those global companies.
Thank you. Joris, I want to let you chime in on that, but maybe also start off the next question. As I said, we should discuss encryption, and I think this cuts both ways, because on the one hand, privacy advocates for a long time have been urging some of the tech companies, some of the big tech companies, to implement encryption, implement it by default on servers and between servers and on the fly. On the other hand, is encryption safe, given that we hear that governments are perhaps colluding with industry or subverting industry and corrupting the standards, building in backdoors? Like, is there anywhere to hide? But please do refer to the localization first, if you want.
Yeah, so I think when thinking about technology solutions in response to this problem of surveillance, and so the type of surveillance that I'm particularly interested in the moment in my research is this transborder surveillance, the transnational type of surveillance. I think it's an especially complex topic to be addressed by law and policy, and I think it will still. I think I lost my microphone.
That was NSA.
Hello? Yeah. Test. So I think that is particularly complex and warrants a lot of discussion in policy and academic circles. And so what I would add, looking at the tech solutions, I think we have to look at like the technology as a solution, but in combination with the way it's implemented. So I would say technological and organizational solutions. Now, I think you cannot just look at encryption without seeing the way in which it is organized within a service provider and in relation to the users. And so one of the questions of course, like who holds the keys, no? And I think we have seen also in the US recently in cases such as LavaBit that you can organize things in a way that you think you are offering a secure product, even with regard to the possibility of lawful access and surveillance of the users, and that turns out to be not necessarily the case. And this is very complex. So one of the interesting things at the moment, in particular in relation to this transnational type of surveillance, is I think that from the perspective of the potentially surveilled, for instance in Europe with respect to the NSA, there are, like if you look into it, there are purposes of surveillance that we are not going to agree that they're proportionate. No, so I think that puts actually a lot of pressure on technology actually providing the kind of safeguards that the law and policy framework is unable to give. No, so and then when you start looking into that, I think we all have to, we have to accept that we're not going to live in a perfect world wherein these localization or encryption type of mechanisms and maybe also technological facilitated transparency and oversight mechanisms that are possible, that I would say that's a third category, in which these measures are going to make things safe and NSA-proof. That's kind of a word that we've heard a lot. But they could help to provide additional security. And I think also what I've heard from the previous panel, where the EDPS is looking like, we want to see our European institutions and the institutions responsible for large data sets of European citizens, they should be secure. No? And then if you look at the potential of those databases being accessed in ways that are disproportional, no? Like you cannot, like there are no good guarantees if you look at the US legal framework and some other legal frameworks that are not even clear enough to be discussed in other countries. Then you see that puts a lot of pressure on the technology to provide this kind of solutions, and I think that is something to look into.
So are you saying that we shouldn't expect perfect privacy and security because the legal framework will inevitably allow for some degree of government access, but that doesn't justify the current dismal state of affairs?
So, yeah, I think like that thing of like you shouldn't expect things to be completely solved in this sphere. I think like we can all probably agree on that. No, and but there, what direction then the debate should take? So one, it should to a large extent actually be about purposes. No, it should. What is the surveillance being used for? And I think there's a bit of a danger to end up in a very techno-legal type of debate about the capacities and what are the technological solutions without having a proper discussion about what are legitimate types of transborder surveillance for the intelligence communities. And I think that is a discussion that should take place also at the European level. Now it's like we're talking about a situation where the transatlantic problem is not the only problem. There's also GCHQ and the UK, and there are other European countries that are spying on each other in these ways. So that is something we have to organize a proper discussion, an international discussion about the standards for this type of surveillance. And I think we are still, we're only at the beginning of that discussion. It will need to happen. We will need to agree. People will need to agree on some proper safeguards in that respect, because otherwise you just put enormous pressure on the technological and economic and just societal environment more generally.
So I don't want to dive too much into a one-on-one, although I must say I'm enjoying it. But isn't what you're saying, doesn't it require us to like agree on some common definition of a terrorist, which is obviously something we can never agree on because one's terrorist is another's freedom fighter?
So I think terrorism is like the kind of example where there may be actually quite a lot of agreement possible, no? And but I think there are a lot of other purposes for intelligence gathering that are like much more complicated to agree on, because they're in the political and the foreign affairs and the economic realm, and that is something where I think there'll be just like we need to discuss a little bit more.
Encryption, anyone?
So today was also already mentioned that you could have read, or even now can read, the Twitter from Snowden yesterday, and he also stressed again that end-to-end encryption is not dead, not technically dead. On the other hand, it has not really lived, because, for example, in Germany I can hardly communicate with the public service in an encrypted way as a citizen. And even when we had the chance to have an e-government law, an act on e-government, the end-to-end encryption, which we would have liked there very much, was not interpreted in that way. So could be that, well, there are providers doing your encryption and or using some services. Of course, it depends on the trust model, but why not now having people who are educated better and promoted better in a way that they can handle self-protection? Or yesterday, it's not on encryption, I accessed some European websites and I deactivated the cookie possibility, and then I got only error messages. They helped me. They helped me because they explained this type of error may also occur if you have other cookie settings. It was not about all the cookie stuff we have been discussed so far, so I really couldn't access this website, and first I didn't recognize what was the case. Or with the anonymizing service Tor, that you cannot access many European websites on the public service. I think this is not only that the government does not help citizens, but it really prevents kind of, privacy recommendation configured browsers, which means that even if people want to do something and feel they do crypto parties, they want to educate each others, so there is some network effect, very good. But if we if we support that and they configure it that way and they use it and they have understood a little bit and really they feel they want to do something for their own protection, and then they are blocked in many even public service situations. I think this is something that has to change. So we keep writing letters now, and perhaps it works in some day, but it's really something where the self-idea, so how the public service also considers its own tasks. I think it's really necessary to help people to protect themselves, and also, of course, protect them if they cannot protect themselves, that they are not hijacked to secret prisons or something like that. Also then the government has to take some action. And what we also would like to see more is warnings. If there's really something happening, like the foreign offices, they issue travel warnings. But I hardly have seen any warnings against the crypto algorithms apart from NIST itself. So thanks to NIST, we know a little bit more that there might be a warning issue, but the national bodies responsible for that hardly took up this message.
So even in Europe, privacy by design and privacy-enhancing technologies are hollow slogans.
Perhaps the first steps are there, but nothing more. So really, and we have been discussing that for 20 years, so this is really disappointing.
Jens, Bryan?
Well, on the technology front, I'm kind of mixed minds about it. As a former law enforcement officer, I hate the idea of bulletproof end-to-end encryption. As a cybersecurity lawyer and a father of 2 daughters who are going to have to communicate for the rest of the century, I think it's really the only solution. I think very strong and constantly evolving end-to-end encryption with the originators and the recipients holding the key is the only way we're going to get close to, it won't be bulletproof, but much better privacy protection than we have now. But having said that, I think there's also a lot of other technologies besides encryption that we should consider. And let me give a disclaimer here. I do represent Palantir Technologies. I'm not speaking for them here, but factor that in, what I'm about to say, because it's somewhat self-interested. But
Postal dogs.
Exactly, yeah. Carrier pigeons.
Yeah.
I think that even in the last 10 years, Professor Lessig said many, many years ago, code is law. And even before I represented technology companies, I believe that. I think the ability of technology to protect our rights is much more powerful than the ability of law to protect our rights. And things that didn't exist really 10 years ago, like robust granular access control, audit trails that are not only tamper-proof but also usable to actual human beings like oversight officials, limitations on repurposing and technological implementation and monitoring of that, and in some ways, maybe most importantly, the ability to log and record all the actions that government officials take on data. I mean, one of the most shocking things that's come out to me in the last 6 months is that when the Foreign Intelligence Surveillance Court in the United States asked the NSA to tell them how many times in the last however many days it was, have you mistakenly intercepted a purely domestic U.S. phone call when you were only supposed to be doing internet, they could not tell them, not even within an order of magnitude. And that means they're not tracking what they're doing, or it's a very, very poor form of tracking. And just being able to start to generate data about how useful are telephone toll records, how useful are license plate readers if they're 5 years old versus 3 years old. We don't really have any data on which to make these public policy decisions. So implementing technology that can provide access control and let people know and let governments know what they're doing in a transparent way, I think is at least as important as encryption.
You want to add anything?
Yeah, I think it's right, and the way we see the encryption roadmap going forward is a way to ensure that when there is data access requests, they have to go through a legal process, and they cannot just,
break in.
And that is one of the ways that we can ensure customer privacy. And we can then, when it's enterprise data, one of the things we do is, direct to the enterprise for their customers, which is the direct way to do it. So there's ways to do it, and so there remains obviously the laws that allow extraterritorial data access. As I mentioned, it's not the only one that we know from Nova Scotia. There's considerations that the visa court orders you can arguably defend against that extraterritoriality reach. And that is one of the points that we have been looking at. Also, this said that while we have very little information that we can publicly mention in that context because of the legal restrictions which we are fighting against, so we have a more informed debate on that. It is also true that we can say that there has been no enterprise data orders that data which was residing outside of the United States in that context.
Thanks. Before moving to the legal solutions and talking a bit about transborder data flows, the adequacy framework, safe harbor, and what else? And maybe solutions, so national solutions or international solutions, the situation in Europe. I wanted to actually turn to you and open it to questions from the floor, if any. So just, yeah. The gentleman, if you could just introduce yourself. You have a microphone.
Thank you. Hello. My name is Dominik. I'm a student of Universität of Twente, and I work for a German telecommunication company. During the last 3 days, we heard some kind of discussions about this whole NSA thing, just as today. And I'm a little bit confused, actually. We heard today something about terrorism, disproportional stuff, what the surveillance is actually for, and I'm a bit confused. I thought that it was pretty clear that it's not about terrorism or that it's not about catching bad guys. Because if you look at the whole range of what the NSA is doing, they're building in backdoors, they're building in backdoors in software, in hardware. And why are we still discussing something like that on a conference as this? Why are we still pretending that the NSA is doing something that might help us as a world community? So shouldn't we go away from all this framing of the US propaganda ministerium to frame this whole topic into a good thing for us, and go away from this discussion and talk about a European cloud service or talk about the European way of fighting this whole big thing? So why don't we talk about the real problem here?
What is the real problem?
Yeah, the real problem is that we still pretend, or that you pretend, that the framing that the US government sets for us is legit. That's the problem.
Okay, Joris, so the US is a rogue state.
Well, I think what I hear in your question, why don't we get rid of these kind of agencies, in the first place? There's just so much illegitimate behavior. Like, I think I can follow that as a reasoning. So, but to talk about the purposes and what actually the intelligence community are after when surveilling globally, I think it is actually very important to discuss the purposes. So realistically, the intelligence agencies are not going to go away. And I think the discussion of what they are actually after is counterterrorism. Some agencies are very actively pursuing economic espionage. what are the roadmaps, what are the strategies that are pursuing in a much more detailed way than we are sometimes doing. And I think in the end, any kind of framework that provides guarantees against disproportional behavior by those agencies has to rely on some idea of what are proportional purposes. And I think that's actually missing a lot in the discussion. And there's still a lot of unclarity. And it's very clear that it's a broad range of purposes that are being pursued, but the precise kind of, the precise purposes are not. So actually if you look at and I think that was part of what we were planning also to discuss, is kind of what the President's Review Committee said in the United States. And so I would also recommend that looking at the recommendations they have with regard to better oversight over the purposes of intelligence gathering. And there are some interesting kind of directions to put more guarantees in relation to how those purposes are being defined, and to get a better discussion of these kind of purposes, and for instance have other departments within the government take a look at these kind of purposes, whether they're proportional. And I think this is realistically maybe a way forward where progress can be made.
But Joris, just to, I'll let you also talk, but just, Joris, to push back against that again, so, you know, in the previous round, I talked about terrorism being kind of blurry-edged concept, you know, historically so also. But also, you know, even economic espionage, like how do you define these categories? Because foreign intelligence obviously does consist sometimes of, you know, what someone may call economic espionage. So it might not be, you know, one government listening into companies from another country and then transferring the data to its own industry. You know, that may be off limits, but economic espionage, I think, is, you know, would be legitimized probably in a treaty like this.
So I think a lot of economic espionage in the general terms fits under foreign affairs type of espionage, to understand like what are the strategic interests in a country and what kind of policies could be pursued with regard to specific countries. There's also, like, we have seen examples of economic espionage. We've seen examples of specific also companies being targeted because actually to be able to establish new forms of surveillance, new surveillance capabilities. I think there's just a whole range of things. And like more classically in the national security context, there's counterterrorism. There's also the proliferation of nuclear weapons. That's a very classical purpose of national security and foreign intelligence gathering. So it would be good to have a discussion. That I don't think we necessarily have this panel is the appropriate venue for really diving into that very deep, and it also requires certain expertise. Now that like I'm not completely comfortable to dive into that very deeply, but that is a discussion to be had. And a discussion also to be had openly to regain trust that there are certain boundaries to what is considered proportionate for a national security agency to pursue. I'm very worried that discussion is actually taking place very, very nationally. Now that is a very nationally oriented discussion. So it's very hard to produce results in the international context because of that national kind of character of these discussions.
Cornelia, you.
Yeah, just an observation, and it's more a neutral observation on this. After 9/11, the EU-US agreements on counterterrorism, I think, is a good starting point to look at it. We are not in the void on that. There is already agreements out there, and that is the first observation I wanna say. And I would otherwise agree with Joris that I'm certainly not the person who can deep dive into these areas. But from what I understand from the reforms that President Obama has announced, I think there is at least this specific issue addressed in clarification that there is no commercial espionage. I think that was one of the points he raised, and another important point, and I think that is from a business perspective a very important point, because most of our customers live outside of the United States, that he has in his roadmap announced extension of privacy protections to non-US citizens, and that is a very important point for us, and hopefully that will move forward soon.
Bryan.
Well, as the lonely American on the panel and somebody who's looked at American intelligence law for 35 years, I think it's really important to not get caught up in generalities and think about these things in specifics. American intelligence law is amazingly transparent. There's an executive order which is a legal document that binds the US government, including the intelligence community, that's been a public document for 40 years. And under that order, it is a violation of US law for an American intelligence agency to steal secrets from a foreign government or company and give those secrets to an American company. That sort of economic espionage has never been legal in the United States and is not legal now, and President Obama just reinforced that. A more broader version of the same point is this executive order and our laws and the declassified opinions of the court very specifically and explicitly state the purposes for which these programs are allowed to be used. Some are specifically limited to terrorism, and some are specifically limited to specific terrorist groups. Some of them, many of the authorities are broader, but they all are confined by the definition of foreign intelligence, which is basically the same in the United States as it is in almost every other country, which is the American intelligence community is directed to collect information on the plans, intentions, and capabilities of foreign governments. Now, you can take a moral standpoint and say governments should not do that at all, but if you're not going to take that position, then you can easily find what the authorized purposes for U.S. intelligence operations are and what they're not. Now, is it possible that American intelligence officers could act lawlessly and in violation of those rules? It is possible, and there have been some historical cases of that, although I believe both the D&I Review Group and the Privacy and Civil Liberties Board have found no specific examples of intentional violations of those laws by U.S. intelligence officers. So I just think it's really important to actually go look at what the laws actually are. Then, if you think that they're being abused, you want to have the Congress and the courts find evidence of that. But to just simply say that, you know, it's not about terrorism and it's lawless is just flatly untrue.
We should at some point, I guess, address the P Club and review boards and president's speech, but I saw several hands going up, so Chris, and then Casper, and then the gentleman in the front.
Thank you for taking my question. This is a legal, technical question. It looks as though...
Chris Hofnagel, Berkeley.
Thanks. It looks as though network neutrality in the United States is in great trouble. And my question is, should those of us who care a great deal about security and privacy welcome the demise of net neutrality? And the reason, and so I know everybody is about to die about this question, but think about it this way. If you get rid of net neutrality, you can start doing quality of service, and you can start doing path selection. And with path selection, you could say, I want my email to my boss never to leave the state of California, or I want my email to my boss never to leave these certain trusted paths versus going through the AT&T switch in San Francisco. And so all sorts of interesting things could happen, and you could have VPN-like protections for average communications, and we could have quality of service, which would be really nice because it's generally pretty poor, right? And maybe the internet could be more like the landline, like the telephone. I know this question is a little crazy, but I welcome you to comment on it.
So is net non-neutrality a privacy-enhancing technology?
Well, a quick comment from my side. I think it sounds like a very high price to pay to go down that path, and I wonder how this type of solution might be used in places like China, Russia, and elsewhere.
So just a quick comment on this. I think it's a great question. What I heard in your question is actually there was some kind of end-to-end principle in the way this routing would take place and who would have control. And I think that's completely like aligned with what net neutrality is. If the users actually decide the types of paths that the packages are supposed to take, and we develop protocols that allow for that to happen, I don't necessarily think there is a problem with net neutrality. If you add certain like guarantees of like service levels that can only be obtained by having some kind of centralized control, maybe the situation changes. But I think there may be also different factors that you would have to weigh and decide on. So I don't think necessarily these kind of more advanced protocols would stand in the way of having control of the user, the end users over the type of routing, which would, I think, be aligned with net neutrality principles.
Marit?
Yeah, I agree. I wanted to say the same.
Yeah, I would just say probably everyone on the panel is deeper technologically than I am in some of these areas, but my understanding is that whatever the legal regime was on net neutrality, it would be very difficult technologically to allow individuals, all individuals, to have choice about the pathways of their packets without massively slowing down the traffic around the internet. But I could be wrong about that, but I think that's going to be pretty difficult to pull off.
But of course, then you could have a feedback system and different paths. So I think I see already the solution that it does not, it would not count as non-net neutrality. And I think really the net neutrality thing is a very big one. And you mentioned one small thing, which in the original routing specification, it's already there. It wouldn't be so difficult to install, but only the feedback mechanism and the risk for example, anonymity then, that would be interesting. So if you like to do a project on that.
Casper, I think you were next. Here in the front. Just introduce yourself.
Casper Bowden. So I want to go back and take issue with some of the things said about Microsoft's commitment to transparency. If we remember the sequence of events, it emerged midway through the Snowden revelations that Google's traffic between data centers was being intercepted by the NSA, and that Google was not applying a layer of encryption which they controlled between data centers. And then complete silence from Microsoft. And it only emerged that Microsoft was in exactly the same position because of a very blunt question asked directly to the Microsoft representative at a session of the European Parliament Libe Committee inquiry. Now, I have to say that relying on any Microsoft encryption is rather like getting a free mosquito net from the Transylvania Tourist Board. But I guess the question for Cornelia is, now that Microsoft has, for, I suppose, various reasons, decided to increase building data centers locally, are you clearly explaining to your customers that if Microsoft were to receive a Section 702 order about a non-US person, that Microsoft would be compelled to respond to that order and remotely extract that data center, that data from the local data center, just as much as if that data was held in the US?
So first of all, I've been in the hearing where my boss Dorothy Bells has testified, and I've been part of the team who has prepared the testimony, and the order of events is not entirely correct. It was pretty clear to us that this question might appear, and it was pretty clear that we have already a roadmap going on, but at that stage the answer was also very clear, and we were very unambiguous and responded truthfully to it. That doesn't change the fact that the company has decided, based on what we learned regarding other companies, that we will go through this roadmap. And I can't give you a timeline, I can't give you the exact details, but that is what we have afterwards announced. To that, and as I responded earlier, we have actually already, and you might remember that, Casper, in our transparency centers made that clear to customers that this can happen. Now, as I said, at the same time, we are looking at the different self-helps that I have listed, those three, and one of them is legal defenses, and I've explained that already, so I'm not going to repeat it.
Yeah.
Sorry, Cornelia, as far as I know, Microsoft, about 2 years ago, 2.5 years ago, Gordon Bell of Microsoft UK made a sort of slip of the tongue inadvertent admission regarding the Patriot Act, but if you can point me to public statements about the vulnerability of Microsoft customers in respect of FISA 702, I'd be very much obliged. And perhaps I could also just stretch the question across to Marit to get the regulator's perspective. I mean, since we've known about threats from foreign intelligence agencies for a very long time, would a regulator really take the position that both in the case of Microsoft and Google, this amounts to a reckless disregard of necessary information security precautions, which one would expect to be perfectly routine by this day and age?
Yeah, you're right.
We had, I think Cornelia answered follow-up questions already in her previous remarks, so let's move on to the gentleman here.
Tobias Mosches, Datenschutzraum e.V. I would like to ask a question. We have heard a lot about encryption algorithms that have been manipulated and something like this, but my question is much easier. What is with the very principles of the trust situation we have today? We have every smartphone trusts its vendor and it trusts every government more than it trusts the user. Do we need a new legal and technical framework where the users and the companies that are providing the services to users can decide themselves whom to trust and how to easily verify the trust without having the knowledge to fully understand the systems?
Joris, you want to start?
I think that's a really big question. So actually, Omer, I think you have maybe also something to say about that. There's you have a recent paper about maybe to facilitate a little bit more the deployment of PETs, of privacy enhancing technologies, and consider them as forms of data protection and information security for end users. And I think that is actually something where we could start also in the European discussions to have much more respect for also in the legal system for the deployment of these kind of technologies. I would have to say just this about that. I think generally speaking, the legal framework and judges and courts are going to be relatively hostile to the types of technologies that give real full protection. So if you think about the possibility of end-to-end encryption implemented properly, that makes it impossible for the judge to say, in this case, I actually find it proportional to give access to these kinds of communications, for instance, in a specific criminal investigation. And I think that ability of the judge to decide what is proportional being taken away by the technology, I doubt that there will not be quite a lot of friction, and I think actually this may be one of the reasons why we have not seen much more push, for instance, from data protection authorities for the implementation of these kind of technologies and the respect for the use of them.
Yeah, so what Joris is referring to is a paper that was recently published by Seda Gurses, Claudia Diaz, and myself, about the treatment of privacy-enhancing technologies in policy and legislation. And we do find, as Joris just stated and Marit stated before, that not only do states not accommodate the use of pets, but they actually disrupt and are downright hostile and sometimes criminalize the use of privacy-enhancing technologies. It begs the question of, because obviously in some policy documents, such as the European Data Protection Directive, pets are encouraged. You want to address this, the trust model for end users' devices? Marit?
So you're totally right, and we see it also in the legal model. So the Data Protection Directive and even the regulation, which will not come, there we see that it's always the data controller being responsible, and then the rest, well, has to be probably dealt with, of course, a little bit technical, organizational, but usually contractually. In the draft regulation, there has been now something on more jointness, on data processors, okay, but still, it's always the one. You want to be one to be accountable. And we have already the problem with anonymizers so the principle is unlinkability. We want to break linkability there. And who is then responsible for what? If I, as a company, have already the data, but I want to offer something that people can use anonymizers, that I employ them, but they have to be in a different entity. So is there now a contractual model that I tell them, you do the anonymization for me, that's data processing, by the way, so it's usually a data processor, but you must not tell me, if I come to you to ask for the data, you must not give them out, so disclose them. So it's really something which has not been tackled that much in the literature. We are working on attribute-based credentials and seeing them as a new model that is better than disclosing EIDs, usually in a full-fashioned way. And there we have the same problem, that we have different parties with different responsibilities in a technical framework, but what are the legal conclusions and requirements for that? And even if we put them now in different countries, so it's fun to work with lawyers on that, but I think it's really difficult then to see them live. So because of EID system, I think there is a fair chance. But for other, like smartphones, it's more difficult even to have those services, probably because of the business model. Because then who takes the risk for what and so. But otherwise, looking 20 years ahead, this might be the usual fashion, like with service-oriented architecture, that we have already services that are provided by different players and have to interact in some way. So why not having that? And I think this is also one of the later answers. We have to remove everything from the central model. The internet was designed to be in the more decentralized, so being prone to some central attacks, but it has developed into the other direction. So there are very few centralized players and central ways to get the data. And not only the Chinese firewall, but there are so many other possibilities.
Yeah, but I think having said that, the current legislative and regulatory framework is based on a premise of a trusted controller in European parlance who gets your data and thereafter cares for you, what is called accountability. And I think if anything, the framework is shifting more to that, to like use-based as opposed to collection-based regulatory model, which means more trust to the controller.
Yeah, but the question is, who decides who's the trusted controller? So if I have a smartphone, I have already nearly every government has a key on the smartphone that can do more than the user can do on the smartphone. So the question is, who decides how can I, if I am a company and I try to provide trust in my services, how can I provide the trust under circumstances I don't control the data I have?
Okay, I think we may have time for one more. Anyone? Yeah, right there in the middle.
Yes, thank you very much. Just a quick question. Nigel Hickson, ICANN. I just really wanted to ask the panel, given the earlier discussion on the cloud and where clouds can be trusted, so to speak, what the panel think of certain statements by companies saying, come to us and we'll just protect your information and keep it within one jurisdiction and your data will never go beyond that jurisdiction. In light of some of the comments made by the panel and some of the technological challenges of that, I just wondered what the panel thought of that. Thank you.
Yeah, Bryan.
Well, I would just say, you know, I already mentioned that I think in terms of law and jurisdiction, it's impossible for any company to guarantee that wherever data is stored, they can protect it from a particular legal process. On the technical side, I think the LavaBit case in the US, and if you don't know this case, you should really look into it, sort of demonstrates how difficult it is for even a company that's committed to trying to engineer a way to prevent lawful government surveillance to actually be successful. I would not recommend any of my clients make those kind of guarantees because I don't think they can be kept right now.
Jens?
I would just add to what I said before. We don't think that these types of solutions are effective remedies to concerns around mass surveillance. I think the solution has to be that the rules governing access to information by governments are consistent across at least the democratic world, and that there be agreements among countries as to how this is to operate, including how one country will deal with data concerning another country's citizen, etc. And we've said that from the beginning in these proceedings.
Thank you. I feel, for some reason, that we'll be here next year discussing some of these same issues. So, you know, this topic is certainly far from being settled. Thanks a lot for being here, and thank the panelists.
Thank you.